Hello, everybody. Roxanne Govari here, and I am so excited. I have an amazing guest today. He is a rock star in his area of expertise, Daniel Zarki. Daniel is a real estate attorney, and he comes with a wealth of knowledge. And anytime you have any real estate trouble, you can refer to Daniel, and he's going to make all the troubles go away. So, welcome, Daniel. Thank you so much for being here.
Oh, I'm very happy to be here. Thank you for having me, Roxanne. I've enjoyed getting to know you through Lawyers Club over the last couple of years, and excited to see you at the event tonight. And yeah, I love talking to you and your agents and anybody who can benefit with some real estate help.
Well, thank you so much for being here. So Daniel, tell us a little bit about yourself and about how your business work and what areas and what matters you cover.
Sure. So I work for a firm called Patton Sullivan Brodell, and we specialize in um, real estate litigation, and some business litigation as well. So what we deal with is basically every manner of real property law, whether it's a dispute that arises after a property transaction or either from the seller or the buyer's perspective. We also deal with other really minutia real estate issues like easements, title, boundary disputes, things like that. But what we've been dealing with a lot recently, which I'm excited to talk to you about today, is specifically looking at cases that arise after a transaction. So those are the instances in which somebody sells a property and then the buyer, after they take control, after the sale has closed, identifies some sort of issue that they believe is a affects the value of the property and was not disclosed, and they then seek some sort of relief from the seller for the damages that they allege that they've incurred. And so that's something my firm has been dealing with a lot, particularly recently. And there are all sorts of different manners in which those facts can come out. And so that's what I'm excited to talk to you about today.
Excellent. Okay. Well, real estate disclosures. That's a big topic, and it's one of the topics, frankly, why most sellers actually hire a real estate agent because we can help them navigate through those disclosures, but that's not always the case or not always enough. So yeah, please tell us about what you're seeing out there.
So I'll just bring up my slides. And Now I call this preventing or avoiding litigation through seller disclosures.
Mhm.
And let's look first. Now we know that sellers have an obligation to disclose facts related to the properties they're selling. Agents also have an obligation, and that is, I'm sure, something that you and your agent deal with a lot. I'm not going to be talking about that today. What I'm talking about is specifically agents helping their seller agents, their seller clients, do their disclosures. So we're talking about seller disclosures, not agent disclosures. Those are similar, but they are different. Um, and the obligation for a seller to disclose comes from both common law and statutory law, and it's set forth. It's described in this case in a way that I think is pretty clear. It basically says that where the seller knows of facts that materially affecting the value or desirability of the property, and knows that those facts are not known or within the reach of the diligent attention and observation of the buyer, the seller is under a duty to disclose them to the buyer. And the undisclosed facts are material if they would have a significant and measurable effect on market value. And basically, if they fail to do so, fail to present those documents fail to disclose that information to the buyer, then they're subject to liability for misrepresentation, or the way it's often phrased in the lawsuits that we see, they're liable for fraud,
Mhm.
because it's fraud to sell a property and not disclose material facts related to that property. Now, there are a few buzzwords here that are a little bit difficult to understand. One is affecting the value of the value or desirability of the property. What would affect the value or desirability of a property is everybody would probably disagree about what those are, um, as well as within the reach of the diligent attention and observation of the buyer. Now, again, that's a situation where the seller may think that something that related to the property is obvious, and the buyer would obviously know about it, but that's debatable. And then we're looking at a significant and measurable effect on market value. Once again, um, that is up for debate. And what you don't want to do is believe that your interpretation of these terms is correct, but ultimately you're waiting for a jury years down the line to make that decision for you. So what you want to do is disclose everything that you can. Now, the buyers of property do have some obligation of due diligence, described here in Civil Code 2079.5. Nothing in this article relieves a buyer to exercise reasonable care to protect him or herself, including those facts within diligent attention and observation of the buyer. Now, that's the same language that was mentioned in the case right before. But once again, because diligent attention and observation are subject to debate, buyers will always argue that they were not on notice of those undisclosed defects and therefore had no obligation to investigate issues they did not know existed.
Mm-hmm.
Now, why does this matter? Well, most, I'd say the vast majority of real property transactions in California use the California Residential Property Agreement and Joint Escrow Instructions published by the California Association of Realtors. I mean, Roxanne, would you say that most of your transactions use that form?
Unless they're brand new construction where the builder has their own contract, or if it's a foreclosure where the lender has their own contract. In every other case, I would say we're using the California Association of Realtors contract. Yes.
Okay, right. And so the CAR form, it includes mandatory mediation in a dispute and attorney's fees granted to the prevailing party. Now, what that means is that if you have a buyer who feels that they've been aggrieved, they feel that they can at the very least show a tiny bit of misrepresentation, even if it's a relatively small value, they can feel assured that they're going to recover their attorney's fees at the end of it. And that means that they are pretty bold about going out and demanding some sort of satisfaction, because there just is a very limited downside to those buyers. Now, as it relates to you, Roxanne, real estate agents often get brought into these cases too as a defendant, whether they had actual knowledge or involvement in the defects or not, because realtors have insurance and they represent a deep pocket for settlement funds.
Yes.
In comparison, the seller of a property, their fraud or their damages would almost never be covered by insurance. But because the realtor's liability would be based on errors and omissions, it would be covered by insurance. And
Right.
that's not fair, but that's just the way that a lot of these cases go. And so this is a situation where, again, you're not dealing with the agents' improper disclosures, you're dealing with the sellers, but the agents get roped into it anyway.
Yeah.
So how can we avoid litigation just by making sure the seller's disclosures are adequate to begin with? Well, as I mentioned before, there's a temptation for realtors to tell their clients to just disclose everything. But as I'm going to show in these slides, that is often not the best advice, because what you actually need is to go a bit beyond that. And just saying everything doesn't really help a seller. So let's look at case number one. In this case, the sellers owned two adjacent parcels. One had a beautiful old house, one had a small old commercial building. The sellers obtained city authorization from the Planning Commission to subdivide the parcels and renovate the commercial building into a new residence. It was roughly going to be on the same foundation and the same height. The sellers disclosed to the buyers that they then went on to sell the old house, and they disclosed that they were going to renovate the adjacent parcel, but did not disclose that the architectural drawings themselves had been approved.
Mm.
The buyers found out about 6 months after the sale closed that the renovation next door was already underway and had already been approved. And they felt that that robbed them of their ability to participate in the planning process. And particularly, they were concerned about privacy from this new house that would be next door. And that was enough for them to sue. Now, you may agree or disagree as to whether this was a material fact. Is a material fact, is the existence of approved architectural plans on a neighboring parcel a material fact? Um, Specifically, when they already disclosed that it would be renovated, that's debatable. But it was enough to drive about 4 years of litigation and probably $1 million in total attorney's fees expended just to finally get this case to a conclusion before trial. So that doesn't even include the cost of trial. And let's look at case number 2 with concealed fire damage. This was a 100-plus-year-old house. There was a fire somewhere in the early 1900s. And they sold the house as is and disclosed that there was a fire history, but they didn't mention specific fire damage anywhere in the disclosures. The buyers bought the property believing that it had mostly been repaired. After they bought the house, the buyers found a lot of water intrusion during the atmospheric river. And when they began making the repairs, they found that a lot of the structural walls were filled with charred wood, and they believed that, and that led to substantial repairs and expensive building code upgrades. And the buyers claim that the sellers knew about those specific pieces of charred wood throughout the house and concealed them. The sellers claim that the buyers were put on notice of the fire damage, and they would have had a duty to do diligent work to investigate. So this is a case that's currently pending, but this is one where clearly the buyers and the sellers are seeing the duty of disclosure and the duty of due diligence by the buyer differently. And whether this case resolves or not, it's going to require a substantial extent of attorney's fees and costs to get from what should have just been a cut and dry purchase to the end. And the third one that I want to talk about is the seller sold a manufactured home in a coastal community. After the sale, the buyer found some water damage and asked the seller about it. And at that point, the seller disclosed that she'd done a small repair to the subfloor. As the buyer continued doing repairs, she found significant water damage. And she claims that if the seller had disclosed the subfloor repair, then there would have been notice to investigate further, and she would have found all this damage before purchasing the house, and basically would not have purchased the house. The seller basically says in response that when you repair something, a defect, and it's no longer a defect, you don't need to disclose it because it's not something that materially affects the value of the house. However, if the repairs had been disclosed, then this dispute likely could have been avoided. So the lessons learned here is many real estate agents tell their seller clients to disclose everything, but don't actually sit down with their clients and help them think about what are the material facts that need to be disclosed. A good agent should sit down and help issue spot and identify what facts would need to be disclosed, even if the seller wouldn't think of them as something material to disclose. And looking at the specific cases, case number 1, the clients were told to disclose everything. That was a very important point in the litigation, is that the real estate agents didn't think they did anything wrong because they told the clients disclose. But what they didn't do is sit down with them and say, let's talk about this neighborhood, let's talk about this property. And so it never even occurred to the sellers that they needed to disclose what was going on a neighboring parcel. If the agents had talked with the sellers more prior to the sale, then that might have been something that they would have realized needed to be disclosed and avoided the litigation entirely. The second case, like I mentioned, that um, the buyers and the sellers disagree about the fire damage and whether it was properly disclosed or whether there was a duty to investigate. But um, if the sellers had disclosed the fire damage more adequately, then they would have avoided liability. Or if they perhaps they went into the sale thinking that they could disclose fire damage, but then didn't need to disclose the individual parts of it, then that's if they had done a different disclosure, then it likely could have avoided a dispute. And then third, the client or the seller believed that they didn't need to disclose former defects that had been repaired. But if that had been disclosed, then likely the dispute could have been avoided altogether as well. So these are all examples where if the seller and their agent had sat down and done a better job talking through everything, then ideally there wouldn't be a dispute. Now, I'm not, of course, rendering an opinion about who was right or wrong in any of these instances. And I'm not saying in many of these cases the seller may have done a perfectly fine job, but regardless, buyers just have a very limited downside due to the attorney's fees clause in the CAR form, and they'll look for any reason to accuse sellers and agents of wrongdoing. And beyond just disclose, it can be helpful to go above and beyond in the disclosures to make sure that there really is no wiggle room to allege that there was a failure to disclose and a fraud that was committed. And so that's something that I think real estate agents left and right can do with their clients to help keep people like me out of work, which is, I think, what everybody actually wants. So that's the end of my presentation. I'm happy to talk to anybody with questions, comments, concerns. This QR code, which it will take you to my LinkedIn, so happy to connect with anybody. But yeah, I'd love to chat with you if you have any questions or anything you want to go back over on the presentation. And I'd love to hear your approach on how you help your sellers with their disclosures.
That's a really, really good point with regards to disclosures. To basically, so essentially what you're saying is, to when you're sitting down with the sellers and you're trying to counsel them to fill out the disclosures, keep on poking and prodding and seeing if you can refresh their memory, or have them think of things that might come up as issues, and make sure that those are getting disclosed
Exactly.
from the get-go.
Exactly. And especially if the real estate agent knows, real estate agents have been through this before. They've dealt with plenty of sales, and they know what kind of facts might end up causing a conflict down the line. And so I think it's worth maybe even raising those and asking, are there more repairs to disclose? Is there damage? Is there water damage? What have you've owned this house for 20 years. I'm sure you've done some work to it. And a lot of the transfer disclosure forms and the seller property questionnaire, they have those questions, but it really is important to answer those truthfully and adequately. And the agent helping the seller through the process can really make sure that they do a better job of disclosing everything that might cause a fight down the line.
Let me ask you this, because a lot of the times I come across sellers, either sellers that are trustees or sellers that are administrators of a probate, and in both cases, their knowledge is limited, but not that limited. In other words, they have never lived in the property, but like, for example, they're adult children, and so they may have moved out of the house, and never lived with the parent in the house. But since they have been adult children and the parent has been living in that house, they've been helping with the repairs of the house or maintaining the house, but technically they've never lived in the house. So
Yeah.
so the burden or the duty of disclosure in such cases, how would you say that they have limited duty to disclose and therefore they don't need to fill out the disclosures as thoroughly as they would have if they have ever lived in the house? How would you counsel them to treat those types of situations?
Well, I think for those situations, it's important to be um, very upfront with the buyer that the seller does not have personal knowledge about a lot of those a lot of the factors of the house. There are specific provisions that exempt trustees from disclosure obligations,
Mhm.
um, which is all described in Civil Code 1102.2. But the yeah, I would say, and I've actually dealt with a case like this recently where our client had a power of trustee because her parents were had health issues and she didn't know anything about the property and there was a dispute with the buyer. I think it's important to be upfront that the buyer, I mean, excuse me, that the person managing the sale doesn't have any personal knowledge of the house, because I think with buyers, they're assuming that whoever's selling the property would have some knowledge of it and would be disclosing the information that is within their knowledge. And if they understand that the seller is not somebody who lived in the house and doesn't have that information, then they might take the extra step of doing another set of inspections or another degree of due diligence just to make sure, because they know that the seller disclosures are not going to be adequate or not going to be up to the normal level of a seller who lived in the house.
Hmm. Right. So basically, in a case like that, disclose what is within your responsibility and duty, but you're not obligated to provide as much information. And
Right. Well, the disclosure obligation has always been limited to what you know.
mhm,
So, what there is, even somebody who lives in the house, if you didn't know about a defect, you didn't have the obligation to disclose it, right? And so that is, of course, the rub of a lot of these cases is what did they know, and everyone will disagree on that. And that can extend to, you might see that in a case where somebody lived in the house for 20 years and there was some water leak or foundation problem, and that maybe that's been in the house for 5, 10 years, but the seller just didn't notice it or didn't have any reason to know that it was there. And then uh, down the line, they sell the house and the buyer has a problem. Or if you look at the case I mentioned with the fire damage, it wasn't until there was a really bad rainstorm that there was water intrusion through
mhm.
the fire damaged wood. And so it is conceivable that they lived in a house with a charred wall and just didn't know because they didn't have the occasion to discover it. Now, again, I don't
Wow.
know what they knew, but it is conceivable in all these situations. If the seller doesn't know, then they don't have an obligation. And so with a case like that, I would be upfront about what they did and didn't know, but beyond that, you can only disclose what you know.
Right. Right. Okay, very good. Well, thank you so much. This is really valuable information, and of course, it is great information to make sure that we all will stay out of trouble and stay out of your office.
Yes, that's the goal. Is I hope I never see you again. That's what I tell people when we end our cases. But like I said, I'm always happy to talk to your agents. I'm happy to talk to any buyers or sellers that may be facing an issue like this. Whether even if it's just that the person on the other side has expressed some sort of dissatisfaction, or if your client bought a house and found a problem with it.
Right.
Um, happy to talk through the options with them, and hopefully we can, hopefully we can figure out a way forward without incurring $1 million in legal fees.
Right, exactly. All right, very good. Well, thank you very much, Daniel, and audience. You have Daniel's information right on the screens, right on the screen. So the QR code is very smart. So thank you for sharing that.
Of
And
course.
and since we are around the holidays, have a happy holiday season as well. And I am also going to share my information in case that you are thinking of buying or selling. You are welcome to reach out to me. There is my phone number, and there is my email address. I also You can also find me on my website or on Instagram. And if you are watching this on YouTube, we really appreciate it if you can give us a thumbs up and press that subscribe button so that as we are posting new videos, you are informed. And such as the conversation that we had today with Daniel, you are able to get valuable information that keeps you out of trouble and onto enjoying your home or enjoying the proceeds of the sale of your home and staying out of court and out of trouble. Thank you so much, Daniel, for joining us today. And we'll see you at another episode of our podcast.
Yeah, thank you for having me. Happy holidays to you and everyone watching. And yeah, good luck. Good luck with your sales.
Thank you so much. We'll see you later.